So my name is Elizabeth Garner and I'm a history PhD student at the University of Aberdeen. So my thesis explores the many ways in which people encountered the founding of an Irish poor law between 1838 and 1847. So the term poor law refers to the body of laws undertaking to provide relief for the poor. In the 19th century, it's most commonly associated with the workhouse system, but by 1845, um, all of the British Isles had a broadly similar poor law set up based on individual pieces of legislation for England and Wales, which were together, Ireland, and finally Scotland, which were each separately legislated. So I have to confess, I'm not a legal historian. So my thesis very much looks at the social and cultural impact of the coming incoming legislation. And in the initial phase of the PhD project, I never considered legal history as something which would help me answer my research questions. Um, Nor really of other scholars working on Irish poor law history, especially for the 19th century period. So that really changed for me with the rediscovery of a key primary source. So early on in my research, I knew that I needed to find quite a substantial collection of primary sources, documents covering the period 1838-47 to get my project off the ground. And I did have a clue. There were a few scattered references to a collection of documents referred to as the Burke Papers. Um, and these consisted of the working papers of Assistant Poor Law Commissioner Joseph Burke. So this role of assistant was very important. The huge physical and administrative structure of the Irish poor law, which included the building of 130 workhouses and the running of annual local elections for the unpaid Workhouse Management Board, this all had to be set up nationwide, pretty much from scratch. And the assistants like Burke were the officials actually based in localities, liaising with locals, and essentially expected to make sure that whatever needed to happen actually happened. So these assistants would then report back to central offices in Dublin and London. So the paperwork provides a really unparalleled, though it must be said, not unbiased picture of the earliest phase of the Irish poor law. So I was really excited that a collection of their papers appeared to have survived. Um, However, it wasn't actually that easy to find, but I got a lot of help from the archivists at the National Archives in Dublin, and we managed to locate the papers because, of course, they're not catalogued as the Burke papers. You can see the two boxes here on the slides. Um, and so when I found them, I, of course, straight away began to read my way through their contents. So one box is full of letter books and the other contains official working diaries. And that's really when legal history sort of intruded upon my research because I began to find numerous references to legal matters. So I'm just going to give a few examples. So in June 1839, the Poor Law Commission in Dublin replied to a query from an L. McLaughlin, Esquire. So he wants to know who exactly is eligible to vote in the local elections to select the Workhouse Board, known as the Board of Guardians. So various criteria is discussed, but the commissioners ultimately reply that they feel it to be their duty to submit this point to the law officers of the Crown. And until they receive their opinion thereon, the commissioners regret that they can't offer a more definite answer. So this quite short sentence actually took me totally by surprise because a lot of the literature on the Irish poor law emphasizes the power of the commission and does not mention the role that legal professionals played in interpreting practical points of the legislation. So in this example, we see a very important point. Who gets to pick the guardians? Now, this answer will be drawn from the legislation, but it's legal professionals who are providing the interpretation. So less than a year later, We now have elected guardians in some parts of Ireland, and in March 1840, the Dublin Commission is informed that the Board of Guardians in Parsonstown, County Offaly, which is modern-day Birr, wish to appoint a solicitor to conduct proceedings in cases of appeals against the rate. So the poor rate was the new local tax which supported the local workhouse. So you paid your rate in the Birr area, and then that meant that that payment went just to Birr workhouse. So I'll be getting to legal problems with the rate in a minute. But in this case, the issue is that the guardians wish to have a solicitor essentially on standby. But unfortunately for them, a solicitor or law agent is not included among the officers whom they are empowered to appoint. And furthermore, the Dublin Commission also note that it's not desirable to make any provision for legal proceedings until an actual necessity for it may arise. So this short example really reveals quite a lot, that the Parsonstown Guardians anticipated legal problems with collecting the rate, and also that their ability to access legal representation was restricted and controlled by the Central Commission. So why did the Guardians think there was going to be a legal issue with the rate at all? So the simple answer is that the rate, like every tax, was incredibly unpopular. So we can see here a satirical cartoon from Punch from around 1850. And I've circled the poor rate here amongst a multitude of other taxes, and we can see the poor cart horse here struggling to actually move the cart at all under the burden. So bearing in mind that the rate wasn't popular, it really didn't help that it was very difficult to work out who actually owed the rate and how much that it was. So this basically allowed people to try and claim that they weren't the person who was liable to pay this rate, that it was somebody else. In fact, it was so complex that the Irish Attorney General and Solicitor General, D.R. Pigott and Richard Moore, were asked to give their legal opinion. So this was then printed up and put in a circular, which I've included here on the slide, but we won't go into because it's quite dense. So this was widely distributed in October 1840. So there's many more examples I could show you from the Burt papers, but I'm conscious of time. So we're going to move on to look at another source. So as I went through the topics discussed in the Burke papers, I wanted to explore more court cases rather than just legal opinion. So I knew that I didn't have time to search by hand through local and national court records, hoping to stumble onto something. And in Ireland, there's an additional challenge because many court records were destroyed in a public records office fire in the 1920s. So this led me to the published court digests called the Irish Law Reports. So these are digitized and freely available online, and they're also keyword searchable and have good indexing. So they're really very easy to use. However, they are only from the courts of Queen's Bench, Common Pleas and Exchequer of Pleas in Dublin, so they exclude local court proceedings, which were often the first port of call for many poor law disputes. So the report's poor law cases are not representative of all such cases. So nonetheless, the cases are quite fascinating. So just to give one example, a case at Queen's Bench concerned the salaries of Dublin prison medical officers. So to support the claim that the salaries were fair, a comparison was drawn with the workhouse medical officer for Dublin City. It was noted that for £60 per annum and with responsibility for nearly 2,000 inmates, there were abundant applicants for the workhouse post. This was presented as evidence to rationalise the upper limit of prison doctor salaries, which was set at £74 per annum. So this is a case from 1841. So this shows the Irish poor law interacting in a wider context of Irish institutions. Even though the government authorities responsible for the workhouse and prison systems are different, we see the decisions of the former, namely the wage for the medical officer, is affecting the latter via the court system. Okay, so apart from providing details of Irish court cases, the Irish Law Report also shows that using English and Welsh precedents for Irish poor law cases was relatively common. But to find out the precedents proved unexpectedly challenging, at least for me as a non-legal historian, because the citations appeared like this, with the name of the case and then a footnote, which looked like this, which totally baffled me at first until I found the fantastic website called statutes.org. And on this site, there's a list, it's extensive but not complete, of other published court digests, like the Irish Law Reports, but for all of the UK. And this list contains the full title, the years of the publication of the report, and a link where where a digitized version of the report is available. So now I could finally track some of the precedents that I was looking for. So I had many to choose from, unsurprisingly, but I picked two to show you today, which demonstrate the high stakes involved in some of these cases. Okay, so the first case was with the Limerick Guardians, who fought for the right to resign their office as guardians. So the Central Commission asserted basically that they couldn't, they accepted this public office and they had to serve their full term. And the Solicitor General who represented the commissioners at court presented two English cases, one of which involved the guardians of Braintree Workhouse in Essex. So the cases, both in Limerick and in Essex, revolved around whether the court could grant an order on behalf of the commissioners forcing a certain action from the guardians. So in the Limerick case, actually neither party really came out that well. The guardians were told that they couldn't legally resign, and the commission were told that they couldn't have a court order, that they should dissolve the board for disobedience, which I guess effectively, in a roundabout way, was sort of accepting the board's resignation because they no longer would have had to come together and govern the workhouse. So in a similar case over the limits of legal authority between the Commission and the Guardians, Clone's Guardians went to court for refusing to increase their poor rate. So the Guardians had originally agreed to a rate which would have paid for the building of the new workhouse and its upkeep based on construction estimates. So unfortunately, building costs had run over to the tune of £400, and the Commission wanted this paid for out of the rate. So in the end, the Guardians had to accept this and increase it. That was the court's decision. But this decision was based on a case in Newport in Wales, where Guardians had resisted building a new workhouse, but been overruled. The court stating that it could only judge the legal reach of the commission. So in this case, it found that the commissioners were empowered to force a new workhouse to be built, but it couldn't comment on the soundness of the commissioners' decisions or their decision-making process. And this quote here that I've put up on the screen sort of says it all. The judges agreed it is clear beyond all doubt that this court cannot entertain such a question. So the question being over the discretion exercised by the commission. Okay, so just some final, sorry. Okay, so just some final conclusions. So what does legal history tell us about the Irish poor law? Well, it connects the British Isles in a really organic way. So poor law studies across the UK often follow national boundaries, yet legal history shows connections which span the British Isles. This suggests that legal history may offer a solution to the continued lack of a four nations approach to poor law scholarship. Secondly, the scholarship around the Irish poor law often notes the Irish factors which shape poor law policy, but the examples I've discussed suggest that the experiences of policymakers and administrators across England and Wales actually shaped the Irish poor law as well. So thirdly, the poor law needed legal systems in order to be practically implemented. But this process shaped the system in ways we don't understand because we just don't have a lot of case studies of this happening. So this is a process which needs much more study and has the potential to sort of shed light on how the legal system might have impacted upon relief that was actually given to people through the workhouse system. And finally, legal cases capture a huge amount of local detail, including names, financial details, and sometimes witness statements. So this is information that often has not survived elsewhere. And this makes the legal history of the poor law immensely useful at both national and local levels, and not just to legal historians. Thank you so much for listening.